Section 1. Title of the Code. This code shall be known as the Corporation Code of the Philippines. In this section, it talks about the historical background of the Corporation Code, which is the law governing private corporations in the Philippines and is now embodied in the Batas Pambansa, which took effect on its approval on May 1, 1980. The new code reproduced with amendments many of the provisions of the old corporation law. This bill is intended to supplant the present Corporation Law number 1459 as amended and be hereafter known as the Corporation Code of the Philippines. The proposed code seeks to establish a new concept of business corporation that are not merely entities established for private gain but also effective partners of the national government in spreading the benefits of capitalism for the social and economic development of the Philippines. This section also provides for the scope of the code, which provides for the incorporation, organization, and regulation of private corporation, both stock and non-stock, including educational and religious corporation. It also defines the powers and provides for their dissolution. It fixes the duties and liabilities of directors or trustees and other officers thereof. It also declares of the rights and liabilities of stockholders and members. It prescribes the condition under which corporation, including foreign corporation, can transact business. It provides penalty for the violation of this code, and it also repels all laws and parts of law in conflict and inconsistent with the code. Section 2. Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. In this section, it gives definition to a corporation, wherein this definition is only exclusive to private corporations or to corporation organized under the corporation law. In this section, it talks about the attributes of a corporation. So the first attributes of a corporation is it is an artificial being or an artificial personality. So the reason behind this is a corporation is a legal or juridical person with a personality separate and apart from its stockholders or the individual members who compose it, who as a natural are real person. So even though a corporation is not a real person, the law still treat it as if it is a real person. So the stockholders or members compose the corporation, but they are not the corporation, nor is the debt or credit of the corporation or of its individual members. Liability for debt, ownership of credit. As a rule, a corporation is not liable for the debts of its stockholders, and the corporation is also not individually liable for the corporation debts. They can lose no more than their investment on the corporation, and the stockholders' debt or credit is not the debt or credit of the corporation. Right to bring action. So a corporation may incur obligation and bring civil and criminal actions in the court as long as it is under its own name in the same manner also just like a natural person. So in here a corporation can file a case or bring action to the court as long as it is under its own name. Right to acquire and possess property. So the property conveyed to or acquired by the corporation is in law the property of the corporation itself as a legal entity and not of its stockholder or its members. Changes in individual membership. So likewise, a corporation is distinct from its stockholder or members. So even if there is a changes in the member or there is a new member or even all the member or the stockholder die, the corporation will still exist. Corporation as a creation of law or operation by law. Special authority or by the state required. So, as we all know, a corporation is created by law or by operation of law. So, this means that a corporation is not formed by just mere agreement, just like a business partnership. It requires a special authority or grant by the state. In the Philippines, the law that governs the formation and creation of private corporation is the Batas Pambansa BLG 68, or also known as the Corporation Code of the Philippines, wherein private corporations owned or controlled by the government or any subdivision or instrumentality thereof are created by special law. The only exception to this rule is that the legislative grant or authority is necessary for the creation of a corporation obtains with respect to corporation by prescription. A corporation has a right of succession. A corporation has the capacity of continuous existence irrespective of the death, withdrawal, or insolvency or incapacity of the individual members or stockholders, and regardless of the transfer of their interests of shares of stocks, but the corporation is by no means immortal. So, under the Corporation Code, the life of the corporation is limited to the period stated in the Articles of Incorporation, not exceeding 50 years from the date of incorporation unless sooner dissolved or the period is extended. Corporations created by special laws have the right of succession for the term provided in the laws creating them. A corporation, being a mere creation of law, may exercise only such powers as are granted by the law of its creation. An express grant, however, is not necessary. All powers which may be implied from those expressly provided by law and those which are incidental or essential to the corporation existence may be exercised. Section 3. Classes of corporation. Corporations formed or organized under this code may be stock or non-stock corporations. Corporations which has capital stock divided into shares and are authorized to distribute to the holders of such shares dividend or allotments of the surplus profit on the basis of the shares held are stock corporations. All other corporations are non-stock corporations. The Corporation Code classifies private corporation into stock and non-stock corporation, according to whether their membership is represented by shares of stocks or not. For stock corporation, it is an ordinary business corporation created and operated for the purpose of making a profit, which may be distributed in the form of dividends to stockholders on the basis of their invested capital. For non-stock corporation, it does not issue stocks and are created not for profit but for the public good and welfare. But there are also other classifications of corporation, and this can be distinguished as to the numbers of persons who compose them, as to whether they are religious or not, charitable purposes or not, as to the state or country under or by whose laws they have been created, as to whether they are open to the public or not, as to their relationship to another corporation, as to whether they are corporations in a true sense or only in a limited sense, and also as to whether they are for public or private purpose. Section 4. Corporations created by special laws or charters. Corporations created by special laws or charters shall be governed primarily by the provisions of the special law or charter creating them or applicable to them, supplemented by the provisions of this code insofar as they are applicable. So basically, in this section, it talks about the authorization or creation of private corporation by special laws or charters. The enactment of a special act creating a private corporation is subject to the constitutional limitation that such corporation shall be owned or controlled by the government or any subdivision or instrumentality thereof. And the reason behind this restriction is to prevent the granting of privileges to one body of men without giving all others the right to obtain them in the same condition, and also to prevent bribery and corruption in the legislature. Section 5. Corporators and incorporators, stockholders, and members. Corporators are those who compose a corporation, whether as a stockholder or as a member. Incorporators are those stockholders or members mentioned in the Articles of Incorporation as originally forming and comprising the corporation and who are signatories thereof. Corporators in a stock corporation are called stockholders or shareholders. Corporators in a non-stock corporation are called members. So basically, in this section, it talks about the components of a corporation wherein there are 4 classes of persons comprising a corporation. These are the corporators, incorporators, stockholders, and members. Corporators are those who compose the corporation, whether they are a stockholder or a member. Incorporators are those corporators mentioned in the Articles of Corporation and they are the one who executed and signed the articles of incorporation. So basically, these people are the founding members of the corporation. So all incorporators are corporators, and only a natural person can be an incorporator. Stockholder, also called shareholder. They are the owner of shares of stock. In a stock corporation, they are basically the owners of the corporation since they own stock that encompasses ownership right in the corporation. A stockholder can either be a natural or judicial person. Member. A member used to be called an incorporator who does not own any share in the corporation, but now it is mandatory for them to own at least one share of capital stock in the corporation. There are also three other classes of persons who play an important role in the formation and organization of a corporation, namely promoters who lay the groundwork for the existence of the corporation, and also subscribers who agree to take and pay for original and issued shares of a corporation or that is to be formed or already formed, and also underwriter who's usually an investment banker. Section 7. Founders' shares. Founders' shares are classified as such in the Articles of Incorporation, may be given certain rights and privileges not enjoyed by the owners of other stock, provided that there were the exclusive right to vote and be voted for in the election of director is granted. It must be for a limited period, not to exceed 5 years, subject to the approval of the Securities and Exchange Commission. The 5-year period shall commence from the date of the aforesaid approval by the Securities and Exchange Commission. So in this section, it discusses about the founder shares. Founder shares are defined as shares issued to the organizers and promoters of a corporation in consideration for some supposed right of property. Such shares usually share in profits only after a certain percentage have been paid upon the common stock, but are often given special privileges over the other stock as to voting and as to division of profits in excess of a minimum dividend on the common stock. So a founder share basically may have special rights and privileges such as preference in the payment of dividends, and they can also have exclusive right to vote and be voted. Section 8. Redeemable shares. Redeemable shares. Redeemable shares may be issued by the corporation when expressly so provided in the Articles of Incorporation. They may be purchased or taken up by the corporation upon the expiration of a fixed period, regardless of the existence of unrestricted retained earnings in the books of the corporation, and upon such other terms and conditions stated in the Articles of Incorporation, which terms and conditions must also be stated in the certificate of stock representing the said shares. So basically, in this section, it talks about redeemable shares, wherein a redeemable share, which is usually preferred by its term, is redeemable at a fixed date or at the option of either the issuing of the corporation of the stockholder or both at a certain redemption price. When we say redemption, it is a repurchase or reacquisition of stock by a corporation which is issued by the stock in exchange for cash or property, whether or not the acquired stock is cancelled, retired, or held in the treasury. So basically, the corporation gets back some of its stocks, distributes cash or property to the shareholder, and continues in business as before. Redeemable shares can only be issued when expressly provided in the Articles of Incorporation. In the absence of any provisions, they are deemed redeemable. Upon the expiration of the period fixed, they may be taken or purchased by the corporation regardless of the existence of unrestricted retained earnings in the book of corporation. When corporation is insolvent, redemption may not be made, and redeemable shares may also be deprived of voting rights in the Articles of Incorporation unless otherwise provided in the Code. Section 9. Treasury shares. So basically, in this section, it talks about treasury shares. Treasury shares are shares of stocks which have been issued and fully paid for but subsequently reacquired by the issuing corporation by purchase, redemption, donation, or through some other lawful means. Such shares may again be disposed of for a reasonable price fixed by the board of directors. It expressly empowered the stock corporation, in the absence of a qualified bidder, to purchase or acquire its own shares for legitimate corporate purposes. And treasury shares can be resale, then they may be resold by the corporation at any price the board of directors sees fit to accept, even at less than par, having once been legally issued as fully paid provided such price is reasonable under the circumstances. Treasury shares, being unrealized income, are not considered as part of the earned or surplus profits, and therefore not distributable as dividends either in cash or stock. In terms of voting rights, a treasury share have no voting rights as long as they remain in the treasury uncancelled and subject to reissue. And neither are treasury shares entitled to dividends or assets because dividends cannot be declared by a corporation to itself. Section 10. So in this section, it basically talks about the number and qualifications of an incorporator and how an corporation is created. So any number of natural persons not less than 5 but not more than 15, all of legal age, the majority of whom are residents of the Philippines, may form a private corporation for any lawful purpose or purposes. Each of the incorporators of a stock corporation must own or be a subscriber to at least one share of the capital stock of the corporation. The right to be and act as a corporation does not belong to any person as a natural and civil right, but as a special privilege conferred upon a group of persons by the sovereign power of the state. Until there is a grant of such right, therefore, whether by special act of the legislature or under a general law, there can be no corporation. Since a corporation is merely a creation of law, it can be dissolved at any time by legislative enactment subject to certain limitations. So there are 3 steps in creating a corporation. The first one is promotion, and then we go to incorporation, and then to a formal organization and commencement of business operations. So meaning the corporation will now start its business transactions. Section 11. Corporate terms. A corporation shall exist not exceeding 50 years from the date of incorporation unless sooner dissolved or unless said period is extended. The corporate term is, as originally stated in the Articles of Incorporation, may be extended for a period not exceeding 50 years in any single instance by an amendment of the Article of Incorporation. In accordance with this code, provided that no extension can be made earlier than 5 years prior to the original or subsequent expiry date unless there are justifiable reasons for an earlier extension as they may be determined by the Securities and Exchange Commission. So basically in this section, it states that the corporation shall exist for the term specified in the Articles of Incorporation not exceeding 50 years unless sooner legally dissolved or unless its registration is revoked upon any of the grounds provided by law. And the corporate life may also be reduced or extended by amendment of the Articles of Incorporation. So basically, there's a limit to the term of the corporation. The term shall not exceed 50 years in any one instance. The amendment is effected before the expiration of the corporate term of existence, for after dissolution, by expiration of the corporate term, there is no more corporate life to extend. And also, the extension cannot be made earlier than 5 years prior to the expiration date unless there are justifiable reasons thereof as determined by the Securities and Exchange Commission. And the Corporation Code also places no limit to the number of extensions that can be made. If extended, the continuation of the old and not the creation of a new corporation will persist. And there can also be automatic extension by amendment of the Articles of Incorporation within the 5 years period before the date of the existing term. Section 12. Minimum capital stock required for stock corporation. So, stock corporation incorporated under this code shall not be required to have any minimum authorized capital stock except as otherwise specifically provided by special law and subject to the provisions of the following section. So Section 12 talks about the capital stock requirement wherein the code does not set a minimum authorized capital stock except as otherwise provided by special law as long as the paid-up capital as required is not less than 5,000 pesos. Special laws may require a higher paid-up capital. So there are also Filipino percentage ownership and requirement regarding corporate capital, like in the corporations for exploration, development, and utilization of natural resources, wherein 60% of the capital must be owned by a Filipino citizen, as well as public service corporation, wherein 60% again must be owned by a citizen in the Philippines. And educational corporations other than those established by religious orders and mission boards, 60% must be owned by a Filipino citizen. And for banking corporations, 60% of the voting stock must be owned by a Filipino citizen. Section 13. Amount of capital stock to be subscribed and paid for the purpose of incorporation. At least 25% of the authorized capital stock as stated in the Articles of Incorporation must be subscribed at the time of incorporation, and at least 25% of the total subscription must be paid upon subscription. The balance to be payable on a date or dates fixed in the contract of subscription without need of call in the absence of a fixed date or dates upon call for payment by the Board of Directors, provided however that in no case shall the paid up capital be less than 5,000 pesos. So this section basically talks about the minimum subscription capital and paid up capital. During pre-incorporation, it is required that at least 25% of the amount of the capital stock has been actually subscribed and that at least 25% of such subscription is paid. These requirements are mandatory. Accordingly, if they are not complied with, there can be no corporation that can be lawfully incorporated. During post-incorporation, the 25% subscription and 25% paid-up capital is required not only during the incorporation period but also in case of increase of the authorized capital stock. This is designed to give assurance to the investing public dealing with the corporation that it is financially and actually able to do its operation and undertake to do business and meets its obligation as they arise from the start of its operation. And also take note that call by the Board of Directors for the payment of the balance of subscription is required only when there is no fixed date for payment in the contract of subscription. And also it is not required for the purpose of incorporation that each and every subscriber shall pay 25% of his subscription. Section 26. Reports of election of directors, trustees, and officers. So in this section, it just talks about the report of elections and vacancies. So within 30 days after the election of the directors, trustees, and officers of the corporation, the secretary or any other officer of the corporation, they shall submit to the Securities and Exchange Commission the names, nationalities, and residences of the directors, trustees, and officers elected. Should the director, trustee, or officer die, resign, or in any manner cease to hold office, his heir in case of his death, the secretary or any other officer of the corporation or the director, trustee, or officer himself shall immediately report such fact to the Securities and Exchange Commission. Section 27. Disqualification of directors, trustees, or officers. So in this section, it talks about the disqualification of directors, trustees, or officers. So it says that no officers convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years or a violation of this code committed within 5 years prior to the date of his election or appointment shall qualify as a director, trustee, or officer of any corporation. The said provision disqualifies anyone convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years or a violation of the code as a director, trustee, or officer of any corporation. Section 54. Who shall preside at meetings? The President shall preside at all meetings of the directors or trustees as well as of the stockholders or members unless the bylaws provided otherwise. So this section specifically talks about who the presiding officer shall be during a meeting. So the President is said to be the presiding officer of all meetings of directors or trustees and of the stockholder or members even when the chairman of the board is present. Where the officer entitled to preside is not present at the time for a meeting, it has been recommended recognize that the stockholder or member who takes the floor may temporarily preside at the meeting of stockholder or members pending the selection of the presiding officer. Unless the contrary is provided by the bylaws, the presiding officer may be selected by viva voce vote of the stockholder or members present. Whenever for any cause no person is authorized to call a meeting, the petitioning stockholder or member authorized by the Securities and Exchange Commission to call a meeting, the petitioning stockholder or member authorized shall preside thereat until at least a majority of the stockholders or member present have chosen one of their number as presiding officer. Section 56. Voting in case of joint ownership of stocks. In case of shares of stock owned jointly by two or more persons, in order to vote the same, the consent of all the co-owners shall be necessary unless there is a written proxy, signed by all of the co-owners authorizing one or some of them or any other person to vote such shares or share, provided that when the shares are owned in an end or capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy therefor. So this section basically talks about voting when the share is owned by two or more persons. In cases of shares of stock owned jointly by two or more persons, it requires the consent of all the co-owners in order to vote to such stock, and such consent is not necessary when there is a written proxy executed by the joint owners authorizing one or some of them or any other person to vote for all, and also when the shares are owned in an in and or capacity by the holders thereof, in which case any one of the joint owners can vote said shares or appoint a proxy therefor. Section 57. Voting rights for treasury shares. Treasury shares shall have no voting right as long as such shares remain in the treasury. So this section basically talks about the voting rights for treasury shares. So this section expressly denies any voting rights to treasury shares as long as such shares remain in the treasury. They are not formally cancelled and are therefore subject to reissue by the corporation at some future time. And also such shares are not entitled to dividends. But in case of sale or reissue, treasury shares regain whatever dividends and voting rights to which they are originally entitled. Section 58. Proxies. Stockholders and members may vote in person or by proxy in all meetings of stockholders or members. Proxies shall be in writing, signed by the stockholder or member, and filed before the scheduled meeting with the corporate secretary, unless otherwise provided in the proxy. It shall be valid only for the meeting for which it is intended. No proxy shall be valid and effective for a period longer than 5 years at any one time. So this section basically talks and discusses the meaning of proxy and what a proxy is. So a proxy designates a formal written authority given by the owner or holder of the stock who has a right to vote it, or by a member as principal to another person as agent to exercise the voting rights of the former. It is also used to apply to the holder of the authority or the person authorized by an absent stockholder or members to vote for him or a stockholder or members meeting. The term can also be applied to refer to the instrument which evidences the authority of the agent. In voting by proxy, the right to vote by proxy is a special form of agency. It is specifically recognized in the election of the board of directors or trustees, in voting in case of joint ownership of stock, in voting by trustee under voting trust agreements, and in voting by members in non-stock corporations. In considering other matters, voting by proxy is expressly allowed provided that a corporation may provide in its bylaws the form of proxies of members of stockholders and the manner of voting them. In non-stock corporations, the right to vote by proxy or even the right to vote itself may be denied to members in the Articles of Incorporation. Limitations on proxies. Under this section, it says proxies must be in writing, signed by the stockholder or member, and filed before the scheduled meeting with the corporate secretary. Unless otherwise provided in the proxy, it is valid only for the meeting for which it is intended. And a continuing proxy must be for a period not exceeding 5 years at any one time, otherwise it shall not be valid and effective after such period. Directors or trustees cannot attend or vote by proxy at board meetings. Furthermore, a proxy are revocable at any time unless made irrevocable by the giver. Revocation may be made by notifying the proxy holder of the same or by signing a new proxy in favor of another, or by attending the meeting and voting oneself. A proxy becomes irrevocable when coupled with interest, meaning the proxy holder has given or promised the stockholder a consideration in return for the irrevocable proxy. Section 106. Incorporation. Educational corporations shall be governed by special laws and by the general provisions of this code. So this section talks about educational corporation, wherein an educational corporation is a stock or non-stock corporation organized to provide facilities for teaching or instruction. Such corporations normally maintain a regular facility and curriculum and normally have a regular organized body of pupils or students or attendants at the place where the educational activities are regularly carried on. Educational corporations are classified by the code as special corporations and are different from an ordinary non-stock corporation formed or organized for educational purposes. They are governed primarily by special laws and suppletorily by the general provisions of the Corporation Code. Those organized as stock corporations are governed by the provisions on stock corporation as to number and term of directors. Section 107. Prerequisites to incorporation. Except upon favorable recommendation of the Ministry of Education and Culture, the Securities and Exchange Commission shall not accept or approve the articles of incorporation and bylaws of any educational institution. So this section talks about the prerequisites of an educational corporation towards incorporation. So, except as insofar as provided by special laws, the incorporation of educational corporation shall be governed by the provisions of the code, meaning the Securities and Exchange Commission shall not accept or approve the articles of incorporation and the bylaws of any educational institution unless accompanied by a favorable recommendation of the Department of Education, Culture, and Sports. Section 109. Classes of religious corporations. Religious corporations may be incorporated by one or more persons. Such corporations may be classified into corporations sole and religious societies. Religious corporations shall be governed by this chapter and by the general provisions on non-stock corporations insofar as they may be applicable. So this section is under the chapter 2 of religious corporations. It basically talks about religious corporations that can be incorporated by one or more person, and such corporations can be classified as corporation sole or religious societies. So this kind of corporation shall be governed by this chapter and by the general provisions on non-stock corporation as long as they are applicable. Section 110. Corporation sole. So as what I've mentioned in the preceding section, a religious corporation can be classified into corporation sole and religious societies. And so in this section, we are going to talk about corporation sole. So for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. Section 111. Articles of Incorporation. In order to become a corporation sole, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the Securities and Exchange Commission articles of incorporation setting forth the following. So basically, in this section, it talks about the articles of incorporation of a corporation sole of a religious corporation, wherein these are the things needed to be done in filing for an articles of incorporation in the Securities and Exchange Commission. So here are the things that shall be followed. 1. The T is the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of his religious denomination, sect, or church, and that he desires to become a corporation sole. 2. That the rules, regulations, and disciplines of his religious denomination, sect, or church are not inconsistent with his becoming a corporation sole and does not forbid it. 3. That as such chief archbishop, bishop, priest, minister, rabbi, or presiding elder, he is charged with the administration of the temporalities and the management of the affairs, estate, and properties of his religious denomination, sect, or church within his territorial jurisdiction, wherein he is gonna describe such territorial jurisdiction. 4. The manner in which any vacancy occurring in the office of chief archbishop, bishop, priest, minister, rabbi, of presiding elder is required to be filled according to the rules, regulations, or discipline of the religious denomination, sect, or church to which he belongs. And lastly, the place where the principal office of the corporation soul is to be established and located, which place must be within the Philippines. So the articles of incorporation may include any other provision not contrary to the law for the regulation of the affairs of the corporation. Section 117. Methods of dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. This section talks about dissolution, wherein when applied to corporation signifies the extinguishment of its franchise to be a corporation and the termination of its corporate existence. There are two legal steps in corporate dissolution. 1. The termination of the corporate existence, at least as far as the right to go on doing ordinary business is concerned. 2. The winding up of its affair, the payment of its debts, and the distribution of its assets among the shareholders or members and other persons in interest. After winding up, the existence of the corporation is terminated for all purpose. A corporation can have perpetual existence, but however, the law also permits the dissolution of corporations. A private corporation organized under the law may be dissolved either voluntarily or involuntarily. Section 124. Application to existing foreign corporations. Every foreign corporation which on the date of the effectivity of this code is authorized to do business in the Philippines under a license therefore issued to it. It shall continue to have such authority under the terms and conditions of its license, subject to the provisions of this code and other special laws. So basically in this section it talks about a foreign corporation is authorized to transact business in the Philippines under a license issued pursuant to the code shall be bound by the terms and conditions of such license and the provisions of this code. If the license was issued before the effectivity of the code, then it shall continue to have such authority under the terms and conditions of its license, but subject to the provisions of this code and other special laws.